Today I was going to discuss with you um, uh, the pressure which has been surmounted due to the COVID-19, basically on the SME sector, the reforms which has been time and again notified by the government to keep the morale of the SMEs little high, and also to see that the economy of the SME is balanced and is not affected. But how far we are aware of it and how effective it is to us, it's something which we have to look into today and understand all these notifications, how they can be put into uh, um, impact, or how they can be put into the use of our each of our company. Without taking much of your time, because my presentation is quite exhaustive, I will take my presentation up, and then as I am we are going with each and every topic of the presentation, we will start discussing on all these issues. So members, while I am discussing on my presentation, for a better network and accessibility, I'll be putting off my video. Please allow me a minute. There's some issue on the net. Guys, are you able to see my
Yes.
presentation?
Yeah.
Okay. So, as we all know that we are all facing this pandemic of COVID-19. The first important notification which came up was on 19 February 2020, which was declared by Finance Ministry, declaring that COVID-19 is a pandemic and hence force majeure. This is very, very important notification for all of us, all the companies, to understand the importance of this related to your businesses, to your contracts, to your employees, to your government performances, to your compliances. Everything will be summed up in this one notification, which said, when it was declared as a force majeure, it said that the invocation of the clause wherever appropriate, subject to due procedure being followed. The clause does not excuse a party's non-performance entirely by only suspense, but only suspends it for the duration of a period. During the occurrence of such extraordinary event, the entity must notify force majeure as soon as it occurs, and the same cannot be claimed retrospectively. I don't want to explain force majeure anymore, because I know each one of you are aware that what is force majeure as of today. There are several seminars which must have happened on this subject. So we all know what is force majeure and what are its implications, and how it impacts you and what are the steps you need to take. But what is important today is to understand that when the government itself declared a situation as a force majeure, what further it has asked us to do. So it has very clearly said that though the government is imposing or declaring the situation as a force majeure, it doesn't come into play on its own, what we call is suo motu, but there are steps, there are procedures which need to be followed by each one of you for declaring this as a force majeure and taking the benefit. So this is one, that you invoke the clause appropriately within the under the due procedure of law. Secondly, it does not excuse a party in entirety, but it only suspends the performance duration for a particular time during which the lockdown, that means during which the pandemic is continuing or the lockdown is continuing. The third important is this: if you have not notified this as a force majeure, you cannot claim a retrospective effect. That means that today you are aware that there is some compliance which needs to be done, or there is some performance of the contract which has to be done, and which you're not able to do. You cannot sit back on the force majeure saying that I am in force majeure unless you have not invoked that. So if today you are into trouble, you have to invoke it today. If you invoke it at a later stage of time, when the time is over, then you cannot claim a retrospective effect, because you have at the relevant time you have waived your rights. This was the similar situation when the government of Maharashtra um invoked Section 2 of the Epidemics Act and declared that all the private offices will be shut down. Now, what was the impact of this shutting down of all the offices and all this notification of coronavirus being a pandemic, and there was a complete shutdown? Now, of all the businesses, and there was a complete lockdown by the government of the entire nation. Immediately on 20th March 2020, the Ministry of Labor and Employment and of Government of India issued an advisory. This is very important to understand that first, the notification was merely an advisory saying that all the employees of public and private enterprises are advised not to terminate their employees, particularly the casual or contractual workers, from their job or reduce their wages. Similarly, on 24th March 2020, the National Disaster Authority also came up with a similar advice that to all the government of state, union, ministries, and everywhere they send this, that social distancing have to be taken care of, proper national lockdown will be followed, no termination of the employees by any employer, either private or public. But immediately on 29th March 2020, the Ministry of Home Affairs issued an order. This order, the advisory which was issued on March 2020, was then culminated into order by Ministry of Home Affairs on 29 March 2020, which said that the state union ministries, authorities, and everybody, including the private and public employers, be it industry or the shop or commercial establishments, to pay wages to their workers on the due date without any deduction to the period their establishments are under closure due to lockdown. Now, what is important to understand is this: while issuing this order, the Home Ministry made a blanket cover to all industries, shops, and commercial establishments. Now, if somebody has to interpret the industry, shops, and commercial establishment, it would very well be considered that the organizations which are not falling under industries, shops, or commercial establishments will be put out of this, will be brought out of the this notification, this order of 29 March 2020. Because now, if you try to understand this, that a service provider is not a commercial establishment, it is neither a shop, neither an industry. An individual, similarly, the non-profit making organization is not an industry, neither a shop, neither a commercial establishment. But presuming that this applies to all, as the notification itself says, it has not bifurcated or differentiated on any industry, shop, and establishment. It has given a blanket cover to everybody, that everybody, either a public or private or an association or whoever, or government or anybody or any establishment, whether in lockdown or not, will have to continue to pay, maintain its employees. Similarly, on 30th March 2020, the Office of Chief Labour Commissioner, Ministry of Labour and Employment, again set out a declaration that all employers, federations, chief secretaries, departments of government, public or private enterprises, advising that all employees, workers may be deemed to be on duty in case of employments is made non-operational due to outbreak of COVID-19, and not to terminate their employees, including casual and contract workers, from the jobs, and also not to reduce or deduct their wages for the period of the employees take quarantine leave. So this makes it very clear that whether you are a shop, you are an establishment, you are an industry, in whichever form you are, whatever work you are doing, in whatever name you are doing, you cannot terminate your employee, you cannot reduce or deduct their wages, whether you are operational, non-operational, whether your employee has taken a leave to under self quarantine or he has taken a leave on quarantine, you have to oblige to pay, and you have to adhere to all the notifications and orders and advisories which have been time and again issued to you by the Ministry of Labor and Employment and the commissioners thereafter. Now, what has been the impact of these notifications? Now, the questions which have been time again being thrown up or being coming up, or when people are confused to understand, is whether the compliance with the lockdown pursuant to COVID-19 is mandatory for the establishments, irrespective of the nature of work performed by the establishment. Yes, the answer is yes, because there is a guidelines. All establishments except those engaged in providing essential services or engaged in manufacture of essential goods shall be closed during the lockdown. The second question is that, can employees of such establishments work from home during lockdown? If the nature of the work is such that it can be done from home, then yes, they can perform the work from home, subject to the extent of the work they can do. Then the next question is whether the employer is obliged to pay full remuneration to the employees for the work done from home. The answer will be again yes, because the employee is working for you from home. Now, how many hours his work, what he is working, that is not clarified anyway. But since the nature of work is such that he can do it from home due to the social distancing which has been notified under the Disaster Management Act, you are bound to make the payment even during the lockdown, even if your employee is working from home. The next question is whether the nature of work is such that cannot be performed from home. Are such employees required to be paid salary for the duration of lockdown? The answer is yes. Now, suppose you are in industry, you are a manufacturer, but you are a manufacturer of non-essential goods. You are a shop where there is a daily retail shop where there is a daily up coming and going of the customers and clients, and your employee cannot perform the services of a salesman which he was doing otherwise when he was in the shop, and he cannot perform those activities staying at home. In those circumstances, because like the order of 29 March has made it clear that even your employee will be at home, you have to make the salary to him during the lockdown period as advised by the government or by the order of March. So this is again, which is clarity on the note. This is the clarities which I am giving to you on the notifications which have been passed. My questions are still further to be put in, and where I will give you the answers of all the questions. Whether the employer is under any obligation to pay wages to migrant workers in order to mitigate the economic stress caused to such workers on account of COVID-19. Yes, the migrant workers are the employers to pay the wages of the migrant workers without any deductions. Whether the employer can downsize the workforce on account of business slowdown due to lockdown period pursuant to COVID-19. So again, the central government has issued advisories or orders, which we have just looked upon, that even during the businesses non-operational due to COVID-19, the employees will not be removed. There will be no retrenchment. The employer will not terminate his employees and should pay full remunerations without deduction. The next is, can the employer compel an employee to exhaust his or her annual leave while the employee is unable to attend work due to being a self-quarantine voluntarily or due to symptoms of COVID-19? Obviously, this is again that you cannot, neither you can terminate the employee or you can exhaust his the employee can exhaust his leave. Those will be leave which you will have to pay without deduction of any of his wages or emoluments, and those leaves will not be considered as annual leaves. Now, in all this, what has happened is the government, why these sort of notifications has come is, first of all, there was no clarity on how long will be the lockdown by the government. The government, initially it was for stage 1, then it went to stage 2, and now we are in stage 3. So there was no clarity that till what time or what period or how long the national lockdown will have to be continued, and transport will be shut and social distancing will be followed, and the businesses will be shut as a consequence of the lockdown. Secondly, with the fear that after the declaration of the lockdown, most of the employer will reach out to termination of their employees and or retrenchment of the employees, or they would not be willing to make immediate payment after termination what the employees would be deserving at the time of the termination. Therefore, to completely provide a security measure to the employees, the government has come up with these notifications and these orders without understanding that in the long run what would be the impact on the industry of the employers, how would they be able to cope up with these notifications of making a continuous payment to a large number of employees without there being any business transaction or any production of the industry, which will be again a loss to the industry. If there is no payment, if there is no work generation, there is no revenue generation, and if there is no revenue generation, there cannot be any payment either or expenses which a company can bear to itself. What could have been done in this time after this notification after March were imposed, after the extension to the second lockdown? The government could have come up with a modification to these notification, to some extent providing a relief to the employers, entrepreneurs, which was not done. In fact, what had happened is this: the government came up with relaxations in certain other forms to the employers, one of which was the employee state corporation notification, which came up, which merely extended the filing of the payment of ESI contribution from February 2020 and March 2020 to April 2020 and 15 2020, instead of March 2020 to April 2020 respectively. Now, how much of this would be benefit to an employer is something which each of the employer has to look upon when they actually, what payments they make to the employee state insurance corporation, and whether they are in a position to make such payment today or not. Similarly, the Ministry of Labor and Employment has extended the last date of filing unified online annual returns under various laws till 30th April. Now, what are these? What are these various unified annual returns which an employer has to file in respect vis-a-vis to his employees? These are some of the emoluments and benefits which an employer provides to his employee during the term of his employment with the employer. Now, there has been a jurisdictional authority to advise not to take any legal action for non-filing of annual returns for the period for the year 2019 against such establishments. And these acts of the Unified Annual Filing cover Payment of Wages Act, Minimum Wages Act, Contract Labor, Maternity Benefit, Building and Other Construction Workers, Payment of Bonus, Interstate Migrant Worker, Industrial Dispute Act 1947. So all the payments which or with benefits which an employer provides to his employee, this notification has merely been said that, okay, if you're the annual returns that you're filing for 2019 which you have not done has been extended further to such and such period, so not from your, then from that period you can start making your payment, or if you making your filing your annual returns. Now on 27 March 2020, I don't know whether how many of you are aware of it or not. On 27 March 2020, the Ministry of Labor and Employment has amended the Employees Provident Fund scheme. Now, as per this amendment, the commissioner may, on an application from any member of the scheme, whether any establishment or factory located in any area declared as affected by outbreak of any pandemic, permit a non-refundable advance from the provident fund account of such member not exceeding the basic wages and journey's allowance of that member for 3 months or up to 75% amount standing to his credit in the fund, whichever is less. This was again a relief which had come on 27 March, saying that where an employee has a provident fund account, he can make an application to the commissioner of provident fund, and the commissioner, after verification and evaluating and analyzing the application, shall permit the advance, non-refundable advance to the applicant of 3 months of his account amount or 75% of the amount, whichever is less. So this was one. I don't know whether it has been followed or not followed. That I have not yet come across it. So this is what is now coming back again to the payment of the employees. Though this appears to be really very harsh, especially when we look upon the SME sector, that the SME sector is a sector which is considered to be the backbone of the Indian economy. And today, when the economy is really into a state of crippling, the SME is forced to shell out lakhs of rupees merely for paying the salaries or emoluments or benefits to its employee without generation of any work, without receive of any money from any of its contractual parties who have, where the contracts have also been completed but the payments are yet stuck. So all these have not been taken into consideration, and even of today, and therefore there is a petition which is filed in the Supreme Court of India by a group of SMEs, where the challenge has been to all the notifications to provide relief to the SME sector of India, which has been kept in abeyance and which is pending to be heard finally, because the Supreme Court has asked the central government to file a reply as to why these notifications cannot or should not be strike down against the implementation or imposition to the SME sector of India. So now we have to still wait and see what would be the reply of the central government and what would be the final orders of the Supreme Court to give, and what relief the Supreme Court grants to the SME sector. This is what I was just now reading, that speaking about the petition in Supreme Court. There was another petition which was recently filed in the Bombay High Court, its Aurangabad bench, which was filed another by some SMEs, and this has granted some partial relief to the SME sector, where the High Court has observed that the areas which are green zone, or the areas in Maharashtra where the lockdown has been partially lifted and which have become functional and operational, in such sectors where the SMEs or any industry or any establishment has become operational, but even after being declared operational, the employee is not attending to the work or remains absent from the work, subject to the procedure laid down in law while initiating such action, like social distancing and taking proper care of the employees during during performance of the work. Then in such circumstances, it will be apt for the industry to deduct 50% of the salary or so much of the salary as it may, during which time during which time the employee doesn't show up for the work. So this is a relief which the Bombay High Court has given to the industry, especially to the SME sector, which can be looked upon. Now, Now let us evaluate these notifications. The notifications have made it compulsory for not deduction of the salary, making full payment of the wages, not termination or retrenchment of the employees. This is very clear. Now there are few situations. There is certain which I have been advising to my clients on these situations, that when I interpret this notification, there is one thing which has been missed out, is the deferment of payment. The notification does not speak about deferment of payment, which can be internally worked out between the employer and the employee. Now suppose you have paid a salary of 2 months to your employee. You have to pay a salary for the third month and you are running out, your cash flow is less, pressurized by the notification to obligated to make that payment. In such circumstances, you can always internally work out an arrangement with your employees that you may be making a payment of certain percentage of the payment of the salary now. The balance percentage of the salary can be deferred or spread out over for maybe 2 months, 3 months, 4 months, depending upon the nature of the work, depending upon the strength of the SMEs or strength of the organization, so that you are also not burdened or saddled with the payment of heavy costs. This is something which internally you have to work out, and this is will not be dehouse the notifications which are imposed on the industries, and the SMEs are finding it difficult to meet the requirements of those notifications. So this is one such suggestions which I can make to you, to speak up to your employees and to work out an internal arrangement. Also, you have to look upon the very first notification, that is of force majeure. Obviously, it has been made applicable in each and every nuances and in each and every circumstances what you face today. There is a very thin line when you consider a force majeure. Force majeure means difficulty or impossibility and impracticability to perform an act, though you may be having all the intention to perform, but due to the unprecedented situations you are not able to perform. Payment of salary may be one of it, because you are into a situation when you are forced to do something which you are not able to do something. So impossibility is different from difficulty. A difficult situations cannot be a force majeure, because that is something which you can overcome, which you have created on yourself. But impossibility is something which is beyond your control. So you can, in every aspect today, in every aspect, in every contract, whether it's a labor contract or your commercial contracts or your government contracts or payment or compliances, everything when you look upon, it is utmost important for you to see, to analyze whether this particular performance from you is covered under a force majeure or not. If you're able to look through this and apply this force majeure very tactfully and very uh, wisely, prudently, then yes, you can save so many difficulties which you may face post this lockdown. Now let us look upon certain reliefs or certain reforms which Reserve Bank of India has granted. The moratorium, first of all, the moratorium period of 3 months of EMIs on all the outstanding loans was announced. That means 3 months it will be the moratorium period, and after 3 months you have to start paying, but that payment will be a little higher payment, because you will have to pay for the payment which is post, and you have to pay for payment which is now of the moratorium. So then your payment after the lockdown for these 3 months will be calculated or adjusted in your the future payments which are not locked down. that will be calculated and adjusted and made more. It will increase. So your payment capacity will be increased. Your outgoing will be increased. Then deferment of interest on working capitals. So there is a deferment. The government has tried, Reserve Bank of India has tried to do certain deferment of working capitals, which we will see it later on. Then ease of working capital financing sanction in the form of cash credit. So they have also tried to try to ease on working capital by sanctioning form of cash credit and overdraft facilities, recalculating the power of borrower, drawing power of borrower by reducing the margins. Asset classification. Asset classification is something which we have to understand. Is this, you know that every one of you know that when after a period of 90 days, if you do not perform, if you do not service your loan, after a 90 days period, you are declared as an NPA. Now, this has been suspended. This was suspended because there was a recent judgment which came from the Bombay High Court, where the Bombay High Court has said that this being period of a force majeure, the parties, the companies who have taken loans, who are not able to service the loans, cannot be pushed or cannot be forced to make the payment when they are not in a position to make the payment. And therefore, when considering the moratorium which has already been granted, the NPAs cannot be declared. So any company which is unable to make the payment of its EMI during this lockdown period will not be considered as an NPA. And the NPA will only start after the lockdown is over. But there is a very special package which has been given to the SMEs, which we will consider a little later. Extension and realization. This is very important as far as the exporters are concerned. The extension of realization and repatriation of export proceeds from exports made up to or on July 2020 has been extended to 115 months from the date of exports. Presently, 9 months from the date of export. So your repatriation, your recovery of your funds from your exports have been extended to 115 months instead of 9 months from the date of export. So therefore, you can during this period start writing your letters to your consignees, to the EDs, to the Reserve Bank of India, saying that this is your position, this is where you are, and because there is an extension, I am looking out to recover it post the lockdown, and how much further time you need. So once you start writing these, it may be a possibility that they may look upon each and every case to each and every situation or each and every issue on a case to case basis, and it may happen that this 115 months which has been extended today may, after considering each and every case, may get extended for further period for that particular case. It may not be blanketly for everybody, but on a case to case basis they may grant you further extension beyond 115 months. But yes, you have to start your writing or your exercise of writing your letters, creating your documents, creating your evidences as a matter of force majeure right now from today. Similarly, target long-term repo. Now, target long-term repo, these are securities, internal agreements of investment agreements which are executed between the Reserve Bank of India and the other banks of India, where Reserve Bank has infused or may infuse or about to infuse 50 crores to be availed by small and medium enterprises, by NBFCs, MFIs, to help refinancing SMEs for maintaining their healthy cash flows. Similarly, the refinancing facilities of further 50 crores has also been extended to NABARD, SIDBI, NHB, NBFCs, MFIs, so that they can provide further facilities to rural sector, agricultural sector, SMEs, by way of special refinancing facilities to meet sectoral credit needs. So this is something which will be helpful to SMEs, but you have to start talking to your banks from whom you have taken up your loans. You have to meet them, or you have to email them. You have to start discussing your present credit facilities, your present credit lines, and how further, in view of these reforms which the RBI has issued or RBI has imposed, how can they be of help to you. This is important, because unless you don't go and reach out to them, you will not come to know how they can help you, and they will not be able to reach out to you, because they may be having several and hundreds and lakhs of thousands of customers. They can't reach out to everybody, so they will look only on to case basis to the people who reach out to them. Now, in order to encourage bank to deploy surplus funds, while they are executing these documents, the Reserve Bank of India and other banks have executed these documents of reserve repo, the liquidity adjustment facility, which was even Reserve Bank of India has an recovery rates of interest from the other banks when it lends out the money to the other banks. So it was 4%, which has been reduced to 3.75% with immediate effect. Now, as I was discussing with you, the NPAs which Bombay High Court has considered, that the moratorium period has considered, it's here, which I have mentioned in my presentation, extended completely till the national lockdown comes to a complete end. So once this lockdown comes to a complete end, you have to see that this moratorium period, when you have not paid your interest and when you are making the payment of interest, how you can protect yourself of being declared as an NPA. So this 90 periods have been extended till the lockdown gets over in completely, whenever it gets down over. So the High Court has made it open that whenever it gets down over, after that time only the NPA will start. Otherwise, there is no NPA as of today. No bank can declare you as an NPA. Now, let's see what Ministry of Corporate Affairs has taken measures for reducing the compliances of Companies Act on corporates. First of all, no additional fees shall be charged for late filing of any documents returned. Now it has extended the period till September 30, 2020. There is a requirement of holding board meetings, which can be done now on VCs. So the interval has been extended to 120 days. Instead, it was earlier by 60. So now you can hold your board meetings, prescribe the interval, extended, the intervals of 120 days has been extended. So until 30th September, those who have not held their board meetings, they can hold their board meetings now. Then the auditor's report, auditor's order, which is supposed to be filed by private companies. This is applicable only to private companies, which is having paid up capital or reserves and surplus not more than 1 crore, or which at any point of given time during a financial year has taken any financial assistance from any bank or financial institution, which does not again exceed 1 crore. They can file their auditor's report at a subsequent date, which has been from financial year, is applicable only in the year 2020 and 2021. So when the auditor is filing this report, he has to take special care to provide statement, which should also include maintaining proper records of assets, physical verification of inventory, investment made by the company, and so on and so forth, that your auditors would know better how they have to file the auditor's report. This is important because this is only in respect of the private companies which are not subsidiary or holding company of a public company. Similarly, the independent directors who could not hold a meeting under the financial year 2019-2020 shall not be treated as non-compliance or violation of the Companies Act 2013. So if there is any independent directors, you maybe, if you, any one of you is an independent director and you have not been able to hold a meeting during a financial year, that would not be treated as a non-compliance and will not be treated as a violation. Now, this is important as far as the from public company perspective, that you have the creation of deposit repayment under section 73, which is the repayment of deposits by the companies for the financial year 2021 on April, which was supposed to be done by April 30, 2020, has been extended to June 30, 2020. This may be extended further, but as of now, we are not aware. We are waiting because we don't know if the lockdown gets over by, say, May 17th, or if it takes long, if it again gets extended, God forbid, doesn't happen by 30th of May 2020, then obviously this date needs to, all these dates which are where the extension is provided till June 30, 2020, needs to be extended further. Now, this is again for all startups and newly incorporated companies, where they are mandatorily required to file Form INC 20A within 180 days for their incorporation. They have been given a direct additional limit of 180 days for filing this form. That means the entire time limit provided to them is 360 days from the date of its incorporation. So these new startups are really at the moment secure. They do not have to worry because they have sufficient time in their hand of almost a year for filing INC 20. Foreign-based companies which are here in India incorporated, which are mandatorily required to have one resident director on their board. Suppose if in financial year 2019, 2020, and non-compliance is not treated to be non-violation. So again, the companies which are foreign companies, which are here in India and do not have any Indian resident director, they are safe. There's a general circular which has recently come on 5th May 2020 by Ministry of Corporate Affairs, which has permitted the holding of AGM through video conferencing of audio-visual means, which provide sufficient, but there are several guidelines. It's a whole lot of guidelines which is provided in the notification. I have only been able to put few of here, but if you go through the guidelines, the circular 2020, you will see that there are so much of compliance which you have to do, and so much of you have to follow, adhere to so many guidelines for holding these video conferencing or the annual general meeting. But few of them which I have pointed out is here. Sufficient e-notice have to be given to all members. Financial statements, auditor's report should be shared much in advance to the members. This is very important, that except for businesses which are unavoidable to be transacted, no other business will be transacted. So this is important, that when immediately there is anything regarding to compliances, regarding to any issues, your contract, which cannot be avoided or which cannot wait for the other day, you can transact those businesses. Otherwise, on video conferencing, you cannot sit on the whole day and take it as, you cannot transact any businesses which is not of any importance to be transacted. E-voting is permitted, but before holding this meeting, proper advertisement by publishing in newspapers before the AGM is very important. Now, companies which are listed on stock exchange have to give the notices to the stock exchange and the ROC for these notices. Prior to this, these video conferencing meetings or audio-visual meetings are to be held of the annual general meeting. There was similar notification which had come for the EGM. So some of the guidelines of this EGM has already been incorporated into the AGM. So I would request you, before holding the AGM, if any one of you have not held their AGM as of now till date and are due to hold your AGM, please go through this circular 2020, which has been made effective immediately on 5th May 2020. Before even you go to hold your meetings by video conferencing or audio visual means, I request that one should not, all the companies should not hold their annual general meetings otherwise not then in not compliance with the 2020, because if you file your annual returns, you will have to update that you have followed and complied the circulars of this 2020 while holding your AGMs. Now, let us come to Ministry of Finance, that what packages and what reforms they have provided to us and how they are impactful and how best they can be made effective to the SMEs. First of all, the extension of filing your returns of revised bills have been done to 30th June 2020. Aadhaar bank is again 30th 2020. This is everybody is knowing. The date for payment of your several for your deductions and your several deduction under several schemes is extended till 30 2020. Then date of comment has been extended to 36 2020. Especially this is for those who have received their approval by 31st March 2020. So the people, the SEZ who have been receiving their approvals after that, I don't think so. They will be, these extension will be applicable to them. The extension will yet to come, or you have to write to the Ministry of Finance or to the concerned department that you do not fall under this, and because your approval has come post 31st 3 2020, therefore your commencement operations and your for deductions, claiming deduction has to be extended beyond 36 2020. Now with Vivad Se Vishwas scheme, this is a new act which has been which has just came in February 2020, which said that the payments, if there is any dispute on payment or recovery proceedings which are pending before any recovery officer, or there is any appeal which is filed in the High Court challenging the order of the ITAT, or there is any payment dispute, any dispute which is there relating to your tax, this is a scheme. Please take advantage of this scheme. You can make an application, file this. If you're willing to make the payment, all your interest and your penalties and your fines will be waived. Only the tax which is due to be paid will be paid. Rest everything is going to be waived off. Nothing will become applicable if you take the route of Vivad Se Vishwas, and the time has been extended to 36. So, so again, the due dates for all notices, due compliances of all notices which will be issued has been extended to 30th June 2020. All GST returns for March, April, May, and composition returns extended to June 2020. For delay payments of tax deductions, those who have not paid their TDS, and those who have delayed, usually we were supposed to pay 18% interest. That has been reduced to 9% now. So if you have delayed payment, take advantage. You have to pay 9% instead of 18% interest. Now, this is something which we will talk to taxpayers now this is for those applications to file nil deduction of TDS, tax collected, and TCS, and who have withhold certificates to claim nil TDS or nil TDS has been extended to June 30, 2020. Now, if any taxpayer wants to apply for a rate lower than the one mentioned in the certificate, now there is a certain certificate, your tax deducted certificate mentions the rate, but you want to apply for a lower rate of it, you have to then in that case you have to make an application separately to the CBDT or to the concerned department in this case. But in such circumstances, when you make the application, the validity of 30 days extension will be taken away. So then you will have to make the payment on the date when you are to make the payment. So this extension will no more be applicable if you apply for a lower rate of certificate. So again, one has to be very careful in making such applications and making such decisions. Again, on 5th May 2020, CBDT issued further notifications. Now, it said that filing nil returns through electronic mode, including through registered mobile servicing agencies, is made applicable. Now, this is in case where in a particular period of time, the GST is nil, where you have to file and you have to file your GSTR 3B, which is mandatory. So such filing has been made that you can also make those filings through your mobile messaging services. There is some procedure you have to follow, do your messaging, OTP will be generated, and you make the filing. Now, cases where period of validity of e-way bill generated on 24th March 2020 and so the validity of this e-way bill shall be extended, deemed to be extended till 31st March 2020. So now if you have generated your e-bill and the validity of that e-bill is 15 April 2020 to be filing, which you have not filed yet, which you need to be filed. So now that has been extended for filing till 31st of May 2020. So again, you have to approach your CAs, your accounts, whoever handles your GST compliances, to approach them to see that how well you can take advantage of these. Then there's specific reliefs which has been granted for GST to the SMEs. Now, during the economic fallout, we all know no interest, penalty, or late fee will be charged on GST return filing for companies having less than 5 crores turnover. So all the SME companies which have, so one is this, that if you have delayed in payment in filing, your filing time is extended till what I said is 31st of May 2020. Secondly, if you are and even if there is a further delay, you will not be charged any penalty. So along with the time being extended, you are also not being penalized if there is a delay fee. So there is no delay fee which is charged to you, provided that your turnover is less than 5 crores. Now, for companies whose turnover is 5 crores, then an interest of 9% will be levied. Initially, it was 18%. Now it is 9%. The government will issue all pending GST and custom refunds now as immediately as possible. The government is undertaken and it has vowed that we will issue all pending and we will refund all the customs and GST refunds to the SMEs immediately, which they have expected to around 180 millions billions, but yes, again, all this has to be made effective and how this has to be implemented. To speak with your CAs and clarify this, to which when so after post lockdown, when you are open, there is some you have shell out by
Uh, I think there was a bit of net issues. Just give us 2 minutes to address this. Just gonna
Yes,
go on
again,
mute and discuss it.
you have to approach your CA for getting this. Then there is another SLP which has been filed in the Supreme Court, that seeking
Khushnuma,
waiver of interest on borrowing. Yeah.
we a bit
Hello.
share presentation.
Hello.
Hello.
Hello. Yes. Manmeet.
Khushnuma, we lost you in between. Can you share your presentation once again?
The whole presentation.
Yeah, just the last slide.
Hello.
We missed out on that. If you can share your screen once again.
Yeah. You're not sharing. I'm not. My screen is out.
Yeah, your screen is out. If you can just go back to the platform and share it once again.
Okay. Okay. I'll do that. Give me a minute. I'll do that. Which one was that? The last one on GST, right? This one. This one was the slide. Hello. Hello.
Can you hear me
Manmeet.
now?
Is this was the slide? Okay. This was
Yeah.
the slide.
Yes.
Yeah, I can hear you now. Am I audible? This was the slide which we missed out.
Uh,
Should I say it again?
can you go on the 20th slide, please?
Okay, I'm on 20th slide. Yes, relaxation of insolvency.
Yeah.
Is that all?
Just before that, the one
Okay.
where you were talking about the GST from 9%, from 18% to
Yeah. Okay.
9%.
Yeah. Okay. 19. So,
Right.
so what the government has during this economic fallout, there is no interest or penalty or late fee will be charged on the late GST return filing for companies showing less than 5 crores turnover, and for companies who have 5 crores turnover, the interest shall be levied at 9% instead of 18%. Now, when you look upon this, understand one thing very carefully. On 5th of May, the Ministry of the GST Council and CBDT has just now issued an a notification, a circular saying that e-way bill generated on or before 24th May 2020, which expires by 15th of April, the validity has been extended till 31st May 2020. So in any which ways, your filing of your e-way bill has been extended till 31st May 2020. So you are home to that extent. Secondly, the very the first notification which had come, it already gave you a cover saying that the SMEs which have less than 5 crores will not be penalized, or any interest will be charged, or any rate fee will be charged, having a turnover of less than 5 crore. So one has to very carefully and tactfully take advantage of these notifications, that at one hand you have already got an extension which is very recent, and on the other hand there is a delay, non-application of any interest or penalty. So that means if you are not filing your e-way bill today till 31st of May, you are in any which way is not into default. Now if you further do not make any default, for further get a delay, you are already covered into it. But then yes, I would request you to approach your CA and discuss these issues, because this is, though it appears to be little tricky, it is very important. It is very, very important, so that you are able to secure your funds to a larger extent. Similarly, government has they have vowed and they have declared that they will be issuing all refund of pending GST and customs refund. So again, you have to approach, you have to see and speak with your CAs and see how fast they can get this implemented so that you can have your refunds in your hands, in your place. Similarly, the insolvency, as I already explained, it is both the ways. It's maybe of your gain, it may be of your loss. If you are on this side as a defaulter, you are at a gain, but if you have to recover, then you are at a loss because you cannot invoke these pays. So you have to either follow the old primitive route of going through the recovery proceedings by civil court, or you may take Samadhan portal, which are these two options at the moment. Yes, suspension, they have been brainstorming, they have not come up with any suggestions as yet, and if they would come up with any suggestion, then we may see one more amendment to the IBC proceedings. Now coming to income tax refund, the government is again said and that they will be releasing all pending income tax refunds. Please approach your CAs and ask them to work out on this, then how soon the government. But yes, you have to take these steps because it's very important to have your funds in your place together. You can't leave it with the government when they have given you a scope that please come and apply to us. We will be distributing at least your applications goes, you know that today or tomorrow your funds will be coming back, because anything getting from the government is not very easy, but you have to give it a start. And once you give it a start, you'll go to an end. Unless you don't give it a start, you can't come to an end. Similarly, there is an SLP which is filed in Supreme Court. I'm sorry, it's not High Court, it's Supreme Court, seeking waiver of interest on borrowings during the lockdown period. Now, the Ministry of Finance has said that the lockdown period will be a moratorium period in which the payment of interest will be suspended, and after the lockdown, post lockdown, when you're paying your interest, that will be included and you are paying a higher interest for the period for your suspension as well as your current. So therefore, there is a SLP which is filed before the Supreme Court, which is seeking that for the, and it is especially for the SMEs and small time workers even, but when the order comes, it will be applicable, I don't know, to everybody including the SMEs, that the interest on the borrowings during the lockdown period has to be waived rather than suspended. So this petition is pending and we hope there's some good outcome by the Supreme Court now, in which there are two petitions now which we have seen in the Supreme Court which is pending. One is the borrowing, interest on borrowing to be waived. Second is the scratching down or non-applicability of the notifications of payment of employees funds or employees salaries or whatever to by the SMEs. So we are waiting for some good outcome and good results from these petitions by the Supreme Court, which will be a breather to the SMEs. But pending that, whatever you need to do, what we have discussed till now, has to be done by you proactively. Now the next is, now this is I wanted to share, this is very important, I wanted to share this with each one of you. This is a letter which I wrote on 23rd April to the Ministry of SME. My major concerns which I have highlighted here are there: PSUs to release the payment which are otherwise not received till date by SMEs after completion of the contractual obligation under the guise of a force majeure. Samadhan applications to dispose of in fast track mode any payments to be related. Present banking facilities enjoyed by SMEs to be restructured. Banks to provide financial assistance to the SMEs at a cheaper interest rate. Immunity from EDs to SMEs who are into export businesses and whose payments have not been received from foreign buyers. Time frame needs to be structured for this. SMEs not to be declared NPA and the period should be extended to 180 days instead of 90 days post disaster. Taxation regime should be eased further. Additional infusion of funds boosting the SME sector. Public procurement policy to be strictly followed, giving better scope and competition to SMEs. common channel of connection between MSME ministry and SMEs, since most of the time they don't get a reach out to you, due to which many of their queries and concerns are left unattended and unanswered. Now, in response to this, two things we have already noticed. One is this: the export recoveries have been extended to 115 months. Second, there is a substantial amount of funds which have been infused by the Reserve Bank of India to support the SMEs. These are the two things which we have already seen. GST to some extent have eased out that how the filings have to be done, what is the relief if there is a delay in filing, and so on. We have just seen. Now, what SME has said to my letter, which I will be discussing with you now, and which is very important. Now, in respect of government orders, PSUs, railways, etc., where liquidated damages clause may apply as per the contract terms. Now, what is DPE? DPE is Department of Public Enterprises. So, public enterprises, railway boards, and other ministries, including PSUs, to be approached to allow relaxation in applicability of LD clauses for a period of 2 months from the scheduled date of delivery, execution of order. Delayed payments. Now, DPE, railway boards to be approached for immediate intervention and release of all pending payments to by CPEs, railways to SMEs, even if the related matter is pending with the SMEs. The most emerging challenge during the lockdown period as well as in the post-COVID period would be meeting fixed costs. While this will be burdensome in absence of regular funds flow, the problem will be more intensified if banks, NBFCs create pressure on MSMEs for repayments for the dues. Now, state governments to be approached for taking suitable initiatives to exempt, reimburse the electricity and other fixed charges during this period. So, in the initially, I have already very placed my impact on the force majeure notification which have been issued by the Ministry of Finance. They are trying to give you everything on the plate, but the only condition is that you have to act upon it. When it comes to your contract, you have to read your contract, you have to act upon your contract, you have to approach, you have to write, you have to create a record. Similarly, when it comes to delayed payment, go to the DPE side, go to online, there is a column which says online application, SME support and reach out. Go to that, click on that application will open, put up all your whatever payments are delayed, file as many applications as you can, and see how fast you can recover your payments. Then they say here there is also additional advantage which is given, is that you have to write to the electricity board for giving you an exemption or reimbursing your payments or giving you some sort of relief from the electricity, which is the major consumption consumption output or input for any industry which is into production, or even an office would be running they would be having a huge amount. Even in lockdown, you will be getting your bills every time coming and you have to make the payment. So for which you have to write to the electricity that you are an SME, you are into force majeure, your office is shut, you are not able to enjoy the services of the electricity, so you need a rebate or you need an exemption or you need a reimbursement. Whatever you need, you feel fit to write, you have to write. The only purpose is this: you have to create some document, some record to prove your evidence. Then this was again in the post-COVID-19 period. It will be obvious for SMEs to face challenges from raw material prices. Deliberate with Ministry of Finance to consider reduction in GST rates on raw materials to partially compensate for the prices escalations. You have to write to GST Council. The association to which each of you SMEs belong should take this initiative of making out letters and writing it to the GST Council, to Finance Minister, because somewhere or the other it has to be reckoned and heard in view of the several reforms or advocacy policies which have been outlined for the SMEs. Relaxation in statutory compliance like filing of GST returns in time, timely refunds to GST payments, and some which we have already seen, which has already been covered by GST itself. We have just now looked into it. Now, moratorium period of 6 months for repayment of MSME loans and other forms of debt, together with the provision of no change in the credit rating during the said period. Norms for declaring NPA periods in bank to extend to 180 days for at least next 2 years, as the SMEs need uninterrupted banking assistance to deal with this crisis situation. Interest rate subvention to 3% on loans to SMEs that are healthy and not NPAs. So they have accepted that the NPA, instead of what the High Court has already provided you a shield, SME Ministry has further to this has given you an extension that 180 days for 2 years, SMEs should not be declared as an NPA. Plus, the interest rate has to be subvented for 3% on loans which are healthy and not NPAs. Deliberation with Department of Revenue and Department of Financial Services bring in suitable measures. So we have always seen this one has to now start writing to your banks that this is what the policies formulated by the SMEs. I am to take advantage of these policies. You have to keep on writing, because you are into a position where you have to invoke your force majeure everywhere, for every little thing. For every little thing you have to invoke your force majeure. Now, this was all what was about the government part of it. Now, very quickly, I'll touch the contracts which are not government and which are private. What happens in a situation when you have a contract which is a private contract and you are on the performance side and you are into a position of force majeure? Obviously, the similar would be a situation from the other side, from your other subcontractor who may be in the performance side and you are on the receiving side. So in such circumstances, again, you have to check your contracts. Please check your contracts, whether you have a force majeure clause, whether such pandemic is covered under the force majeure clause. If it is covered, then how it is covered, what, then you have to then take advantage of the notification of 19 February by writing that what is the consequences and how much time and how much time after the post lockdown will be taken. Or you have to create an evidence for it, because if you don't create evidence now of anything, then you cannot claim an advantage post COVID retrospectively. So this is